Chapter 4. Whether probates by the prerogative court are voidable only by sentence, or void. Cases having received contrary decisions on this subject, it will be necessary to make a general inquiry into them, and for that purpose will be given. First, the cases, by which it has been decided, that the probate of the archbishop, where there were not bona notabilia, in another diocese besides that in which he died, is voidable. Secondly, the cases, by which it was decided, that the probate of the archbishop is void, where there are not bona notabilia. Thirdly, the conclusions to be drawn from these cases. First, the cases, by which it has been decided, that the probate of the archbishop, where there were not bona notabilia, is voidable. The first case determined upon the subject is that of V. Jeffreys, cited in Prince's case, in 5 Coke's report, 30. It was decided in 22 Illas, but is cited in Coke's report, in Prince's case, in 42 Illas. And in this case, it was said, that judgment was given in the King's Bench, Pashk, 22 Illas, between V. Jeffreys, that where one hath goods only in an inferior diocese, yet the metropolitan of the same province, pretending that he had bona notabilia in divers dioceses, committed administration, this administration is not void, but voidable by sentence, because the metropolitan hath jurisdiction over all the dioceses of his province, therefore it cannot be void, but voidable by sentence. But if an ordinary of a diocese commits administration of goods where the party hath bona notabilia in sundry dioceses, such administration is merely void, as well as to goods within his diocese, or elsewhere, because he can by no means have jurisdiction of the cause, and true it is that such judgment was given. Here it must be observed that the case was decided at least 22 years before the canons of 1603, and that it was specially referred to in the hereinafter cited case of Bingham and Smeathick, which was decided in the Exchequer Chamber, and quite in contradiction to it. In Sir John Metham's case, 8 Jas. 8 Coke, 135, Sir E. Coke refers to the foregoing case of V. Jeffreys, as to the administration granted by the prerogative court, where there are not bona notabilia in another diocese, being voidable only. In the case of Grange against Denny, 14 Jas. 3, Bulstrode, 176, Lord Coke refers to the foregoing case, and says, in Vere and Jeffreys' case, Part 5, Fol. 30, I did first move this matter when one had goods only in one diocese, and the metropolitan of the same province, pretending that he had bona notabilia in divers dioceses, commits administration. This is not void, but voidable by sentence, because he hath jurisdiction throughout the whole diocese. Within his province he hath the first cathedral church, and is the ordinary, and all other bishops within his province are derived from him. Otherwise it is, where the ordinary of a diocese doth commit the administration of goods, whenas the party hath bona notabilia in divers dioceses, this is void for all. There was no decision of the court in Hobart, 185, but only the statement of council, that formerly there was only one bishop, the Archbishop of Canterbury, and he granted authority to the bishops in their respective dioceses, and retained a jurisdiction over his whole province, and therefore a probate or administration granted by him where there were not goods in divers dioceses, was voidable and not void. The like doctrine, as in the case of Vere and Jeffreys, was held also in the case of Rex v. Login and Froome, 1 Strange's Reports, 73, and upon the authority of that case, Dr. Login the Chancellor, and from the register of the Bishop of Salisbury, were indicted for extortion, in forcing Thomas Hollier, the executor of the will of Mary Alston, to prove the said will in the said bishop's court, where they well knew that the said will had been before proved in the prerogative court of Canterbury, and by reason thereof, they exacted of the said Thomas Hollier 40s. On not guilty being pleaded, there was a verdict for the king. It was moved in arrest of judgment, that it not appearing there were any bona notabilia, the prerogative probate was ipso facto void, and consequently the will ought to be proved before the defendant Login, the testator dying in the diocese of Sarum. Tudley, admitting not void, but only voidable, yet the prerogative court having proceeded in a matter where they had no jurisdiction, that should not hinder the court of Sarum from proceeding in a matter within their jurisdiction. As to the first, before the council had gone far in their argument, the judge stopped them, and declared, that it was not now to be contested, having been often settled, that such prerogative probate is not void, but only voidable, to which the rest of the court agreed. Thirdly, they held, that this voidable probate, being the act of the superior, had so far taken away the power of the inferior, that he could not exercise his jurisdiction, till that voidable probate was avoided. The case was adjourned upon another point, nor does it appear, that the defendants were ever brought up for judgment. This case is, therefore, in opposition to the decision in Sir John Nedham's case, which decreed that the administration, which had been granted by the inferior court before the revocation of the prerogative administration, was, after the revocation of such prerogative, good and valid. In Robinson v. Wobbly, 29 Car. 2, Sir W. Jones, 78, Pagan v. Selby, 14 Jazz. I. 1 Rolls, 143, and in Gold v. Strode, 2W. 3 Carthew, 148, counsel held that administration granted by the prerogative court, where there were not bona notabilia, was voidable by sentence, and not void. Thirdly, the cases by which it was decided that the probate of the archbishop is void, when there are not bona notabilia. In Michigan 26 Illas. 4 Leonard 211, the case was in the King's Bench. In debt, it was found by special verdict that the testator being possessed of divers goods in London, where he died, and also at the time of his death, the Queen being indebted to him in the sum of 41,108, she then residing at Whitehall, the Archbishop as Metropolitan granted license of administration to the Queen, and the Bishop of London afterwards granted license of administration to J.S. The court sent to the civilians to appear in court, and to deliver their opinions in this case. And thereupon Lloyd, Doctor of Laws, appeared and argued to this effect, viz. that in ancient times in such cases, the several ordinaries committed several administrations for the goods in their diocese respective, in which case, the mischief was very great, for the administrator was driven to bring several actions of the administrators of the several ordinaries, vidh. 7. 13 r. 2, administrators 2 liters. But afterwards upon a decree, upon a composition in such cases, the Metropolitan committed the administration, and he said that the administration granted by the Archbishop was void, for as Archbishop he had not to intermeddle within the diocese of another, but as legatus pape, and in the time of Hen. 2, Becket, Archbishop of Canterbury, was styled legatus natus, but now that power legatine is determined, and therefore the authority to commit licenses of administration in another diocese, but in case of bona notabilia, is determined. Abry, Doctor, argued to the contrary, and he confessed that in ancient times every ordinary in such cases committed licenses of administration, but he denied that the prerogative, which is now practiced in such cases by the Metropolitan, was given upon any composition, but that it began by prescription. But he said that posita bona notabilia are not in this case, yet the administration granted by the Metropolitan is not void until it is revoked, for although that the Metropolitan in the right of his bishopric hath not to intermeddle in another diocese, yet in this case because the Archbishop of Canterbury is a patriarch, for in Christendom there are 4 great patriarchs, and 8 lesser patriarchs, whereof the Archbishop of Canterbury is one, and by reason thereof, he hath general jurisdiction through all England, Ireland, and sea. But now by the statute his authority is restrained, for he cannot cite any other out of other diocese by any process, but notwithstanding he may do many great acts by himself, or his chancellor, in every diocese. And he argued very much upon the prerogative of the Archbishop of Canterbury. The justices did not then deliver any opinion in this case. In Bingham and Smeethwick, in the Exchequer Chamber, 37 Illas. Croaks. Illas. 455, the plaintiff had claimed title under an administration granted by the Archbishop of Canterbury, and the court held that the pleading of such administration is not good, unless it is averred that the deceased had assets in divers dioceses, on within the diocese of Canterbury, or that the Archbishop was loci ilius ordinarius. But it was moved by Coke, the Queen's attorney, that the committing of administration being by the Archbishop, although he had not goods in divers dioceses, because it is in his province wherein he hath jurisdiction, is not void, but only voidable by sentence, and it is not like to an administration committed by another bishop, of the goods of the man who died in another diocese, or who had goods in divers dioceses, and this difference had been taken and agreed in the Queen's Bench, and therefore, it was agreed that the plea was well enough, but the justices said that it was all one, and that the administration is void in both cases, and not voidable only. In Sir John Nedham's case, 8 Coke, 135, Arthur Post and Catherine his wife, administratrix of Elizabeth Weldish, brought an action of debt against Sir John Needham, which plea began Michigan 7 James, in bond of 200 litres. Made to the said Elizabeth, to which Catherine, the administration of all and singular the goods which the said Elizabeth had at the time of her death, was, after the death of the same Elizabeth, committed by William, by divine permission, Bishop of Rochester, at Rochester, on 5th February, 1605. The defendant pleaded, that after the death of the said Elizabeth, and before the commission of the aforesaid administration, that is to say, on the 13th of May, 1604, the Dean and Chapter of Canterbury being guardians of the spiritualities, sed vacanti, of the Archbishop of Canterbury, committed administration of the goods, and c. of Elizabeth Weldish, to the defendant, because the said Elizabeth had bona notabilia in divers dioceses of the province of Canterbury, which administration committed by the said Dean, doth yet remain in force. The plaintiff replied, that after the said administration granted by the said Dean, and c. to the defendant, and before the purchase of this original writ, sc. 4th of November 1607, before Dr. Bennet, Commissary of the Prerogative Court of Canterbury, at the suit of the said Catherine, against the said defendant, the administration granted to the defendant was pronounced and declared null and void in every effect in law, upon which the defendant demurred in law. And in this case these points were resolved. Forasmuch as the defendant had not shown in his bar that the intestate had bona notabilia in certain, for this cause it shall be taken that the administration was granted where the intestate had not bona notabilia in several dioceses, but yet it was agreed that such administration was not void but voidable, as it was adjudged in Huvier's case, as it appears in the 5th part of my reports for 29 and 30. Toodly. It was objected, that forasmuch as the administration granted to the defendant was not void, but voidable, so long as it was in force, the inferior ordinary ought not to have committed administration, for the prerogative administration granted by the Archbishop, and the administration granted by the inferior ordinary, cannot stand and be of effect together, and therefore confusion will ensue, and therefore the administration granted by the inferior ordinary was utterly void, and although the said prerogative administration be afterwards revoked, that shall not make the other administration of any better effect, than it was at the time it was granted, because what is void in the beginning, cannot become good by process of time. But it was answered and resolved, that now inasmuch as the ecclesiastical judge has pronounced and declared the letters of administration granted to the defendant null and void to every effect in law, we must give credit to them that it was for causes not appearing to us void from the first. Vide 17 Nullas. Dyer, 339, the like judgment upon the same reason. Also, the administration is but an authority, because he has nothing to his own use, but all to the use of another, and an authority may expect and commence in futuro, and therefore it shall be suspended until the other be repealed or declared void. The case of Porter and Rochester, which was decided in 6 James, and 5 years after the establishment of the canons of 1603, 13 Coke's report, p. 7, relates to the citation of a person out of Essex, which is in the diocese of London, into the Court of Arches, which was held in a peculiar belonging to the Archbishop of Canterbury, but situate within the diocese of London. It was decided that, under the provisions of the Act of 23 Hen. 8, c. 9, the citation could not be supported. The case is reported at great length, and the following forms part of the decision. There is a saving for the Archbishop calling any person out of a diocese, where he shall be dwelling, to the probate of any testament, which proviso would be in vain, if the Archbishop, notwithstanding that act, should have concurrent authority with every ordinary through his whole province, wherefore it was concluded, that the archbishop, out of his diocese, is prohibited by the Act of 23 Hen. 8, unless, in the cases excepted, to cite any man out of any other diocese. And whereas it is said, in the preamble of the Act, in the Arch's audience and other high courts of the archbishops of this realm, it is to be known that the archbishops of this realm, before that Act, had power legatine from the Pope, by which they pretended to have not only supereminent authority over all, but concurrent authority with every ordinary in his diocese, not as Archbishop of Canterbury, and see, but by his power and authority legatine, so as before that Act, the Archbishop of Canterbury was legatus natus, and by force of his authority legatine, usurped against the canons upon all ordinaries in his precinct, and by colour thereof claimed concurrent authority with them, which although they held in the courts of the Archbishop, the same was remedied by the Act of 23 Hen. 8, c. 9, and all that which he usurped before was not as he was Archbishop, for as to that he was restrained by the canons, but as he was legatus natus, which authority is now taken away and abolished utterly. In Turner and Vanstel, 25 Car. 2. 3 Keble, 262, Sergeant Hardy prayed prohibition for the administration in a Canterbury peculiar, in suit by the defendant in prerogative, supposing a will and bona notabilia, which the plaintiff said were none, st non allocata, per curiam, if the beno bona notabilia, the administration in the prerogative is void, HCR 457, and the first administration stands, and the prohibition was denied. On a review of the cases that have been determined on the subject of the probate or administration of the archbishop being voidable, or void, when there are not bona notabilia, some will be found to have decided them to be voidable, and others void. If an administration committed to a creditor be afterwards repealed at the suit of the next of kin, the creditor shall retain against the rightful administrator, and all dispositions of goods by him, pending the citation, shall stand. For this is not like the case of an administration granted by a bishop of an inferior diocese, where the intestate had bona notabilia, in divers dioceses, because the such administration is actually void. An administration is void when granted by a wrong ordinary, and voidable when granted to a wrong person, that is to say, when an administration is granted by a court, not having jurisdiction, it is actually void. There is no doubt of the application of this rule to the courts of the bishops and other inferior ordinaries. In what respect, then, does the prerogative court differ from them? It is universally allowed that all the original jurisdiction belonged to the bishops, and that they committed several administrations for the goods in their respective dioceses, when the deceased left goods in divers dioceses, in which case the mischief was very great, for the creditor was driven to bring several actions of the administrators of the several ordinaries, but afterwards upon a decree upon a composition in such cases, the metropolitan committed the administration. The ordinary had, therefore, the original right to prove wills, and grant administrations of all persons dying within his diocese, and it was only by reason of the goods out of such diocese, that the prerogative court became entitled to the probate or administration. If, therefore, the probate or administration of the ordinary can be considered as actually void, when he is only deprived of his jurisdiction, by the fact that the deceased had goods in another diocese, the reason is more forcible for considering a prerogative administration void, where there are not bona notabilia in another diocese, for the jurisdiction of the prerogative court is solely dependent upon the fact of there being bona notabilia in another diocese. But the reasons assigned, why the probate granted by the prerogative court should be voidable only by sentence, are, that the archbishop has jurisdiction over the whole province, that he was the first bishop and divided his province amongst his suffragans, and that he was one of the patriarchs, meaning, thereby, that he had concurrent jurisdiction throughout the whole province. But all such concurrency of jurisdiction, if, in truth, he ever had such, was prohibited or repealed by the Statute of Citations, 23 Hen. 8, c. 9, and is altogether overthrown by the decision in the case of Smeathwick v. Bingham, it being there decided, that, to support any pleadings by executors or administrators, acting under probates or administrations granted by the Archbishop of Canterbury, Such probates or administrations must be stated to have been granted by the archbishop where there were bona notabilia, or where all the goods were in the diocese of Canterbury, or as ordinary of the place, for that otherwise the pleadings would be set aside. And it must be observed, that the principle of the case of Vere and Jeffreys, upon which the doctrine, that the prerogative probate or administration, when there are not bona notabilia, is only voidable by sentence, depends, was overruled in the Exchequer Chamber in the case of Smeathwick v. Bingham. Sir Edward Coke, then Attorney General, having as counsel cited it, when the court declared such a probate or administration to be void. The first legal acknowledgment of the prerogative court, was by the statute 23 Hen. 8, c. 9, the proviso in that statute reserving to the archbishop the power of citing any person out of a diocese only, in respect of his prerogative. Now this prerogative had been previously defined by the composition of 1513, and this composition was embodied into the canons of 1603, and the 93d canon expressly declares that no judge of the archbishop's prerogative should thenceforward cite, or cause to be cited, ex officio, any person whatsoever to any of the aforesaid intents, for probate of will, and see, unless it should first appear to him, nisi prius constituit in the original canon, that the party deceased, was at the time of his death, possessed of goods and chattels in some other diocese or dioceses, or peculiar jurisdiction within that province, than in that wherein he died, amounting to the value of 5 litres, at the least, decreeing and declaring that whoso hath not goods in such case, in hoc casu in the original canon, to the said sum or value, should not be accounted to have bona notabilia. Provided always, that if any judge of the prerogative, or any his surrogate, register, or apparitor, should cite, or cause any person to be cited into his court, contrary to the tenor of the premises, he should restore to the party so cited, all his costs and charges, and we do pronounce the acts of the same to be held ipso jure, void and of no effect, et actu ejusdem ipso jure vacuo et pro nullis habenda pronunciamus, in the original canon. If it is assumed that the canons do not take away from the prerogative court, the right of granting probates and administrations when the parties voluntarily require them, it is answered that if a voluntary jurisdiction had been intended, it would have been reserved to the archbishop in this canon, in the same manner as the voluntary jurisdiction, in cases of bona notabilia in another diocese, is reserved to the inferior courts by the 92d canon. No such reservation could however have been in contemplation, for the jurisdiction of the archbishop extends only to those cases where there are bona notabilia in some other diocese or peculiar jurisdiction than that wherein the party died, and the jurisdiction in all cases, where there are not bona notabilia, belongs to the bishop and inferior ordinaries, as it is secured to them by the ancient canons, which are not only sanctioned and confirmed by time and practice, but more especially by the statute of 25 Henry 8, c. 19. The conclusion, therefore, is, that if the prerogative court grants a probate or administration where there are not bona notabilia, it makes a grant where it has no jurisdiction, and where the jurisdiction belongs to another court, and such a grant in this, as in all similar cases, cannot be otherwise than coram non judici, and consequently actually void. Should the decisions in the courts of common law, be relied upon as sanctioning the practice of considering the archbishop's probate voidable only, where there are not bona notabilia in another diocese, it will be seen on a careful examination, that those, which decide the probate or administration to be void, have a great preponderance, both as regards the cases themselves, and the correctness of the principle upon which they are decided, whilst those which declare the probate or administration to be voidable only by sentence, were founded on the ground, that the archbishop had a concurrent jurisdiction, which, whatever it might have been previous to the statute of 23 Hen. 8, certainly did not exist at the time of the decision of these cases. When, therefore, it is considered that those cases, which make the probate or administration void, coincide with the provisions of the canons, and that consequently those cases, which make them voidable only, are in direct opposition to the intent and effect of the canons, there cannot be any reason, either from the force of the cases decided, or from the principle on which they are decided, or otherwise, for deeming a probate or administration granted by the prerogative court, where there are not bona notabilia in another diocese, otherwise than void,